After your surgery, you followed up with your surgeon. And as you're approaching the doctor's office, you turn on your iPhone, you turn on the audio, and you slip it into your pocket. And you don't tell the doctor that you're recording this conversation. During that follow-up conversation, the doctor actually apologizes to you for what happened. He says, "This never should have happened. I can't believe it happened. The resident never should have done these things. This is ridiculous, and that's why you have all these problems now." Now, you decide to bring a lawsuit against your doctor as well as the hospital staff for causing all of your injuries. You have smoking gun information. But can you conceal this until the time of trial? Can you use this to ambush the doctors at the time of trial? You want to know the answer? Come join me on this walk on the beach as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer is no. You cannot conceal this if you intend on using it at the time of trial. You see, the discovery process requires that we turn over information that is going to show and confirm that we have a valid basis for a case. This way the defense can see it, they can evaluate it, they can talk to their own witnesses and experts about it. If we conceal this and only use this to ambush the doctors at the time of trial, you know what will happen? At the time of trial, now my client gets up on the witness stand. "Hey, Mr. Jones, when you went in to speak to Dr. Gonzalez about what happened, did you have a conversation with him about what happened?" "Yes, I did." "And did the doctor explain to you what happened?" "Yes, he did." "Tell us what he did. Tell us what he said during that conversation." "Oh, the doctor told me it was all the resident's fault, the doctor in training. And had the resident not done the following things, I never would have had the injuries that I had. And that it was all his fault, all the resident's fault." All right. Now, Mr. Jones, did you record that conversation? "Yes, I did." "Do you have that recording?" "Yes, I do." "Your Honor, at this time, I would like the jury to hear this recording." The defense lawyer jumps up out of his seat and starts screaming and yelling, "Objection, Judge!" Oginski and his client never alerted us to the fact that there was any recording about this conversation. He never provided us any information, not in writing, no audio, no video, nothing. In fact, during the course of this lawsuit, he responded to our request for documents and other information by specifically stating that they had and were not in possession of any audio recordings, any video recordings, or anything else that would be detrimental against my client. And because they have never provided this, I ask that you preclude and prevent Oginski and his client from talking about this, from bringing this into evidence, and I want a very specific instruction to the jury that they are to disregard any knowledge or information about any recording. Now that creates a huge problem for us. Why? Because now what has happened? What's happened is that the jury has been alerted to the fact that there was a recording made. The jury has been told by the injured patient of what he remembers happening during this conversation. Obviously, the doctor is going to deny everything that happened in this conversation. And the information contained in this audio recording hopefully will support this conversation, support the injured patient's claim that yes, this is what the doctor had said. All right, but what happens now if the judge refuses to allow us to play that recording for the jury? What happens then? Well, that creates a huge problem because now we no longer have corroboration, we no longer have supporting evidence to confirm exactly what the injured patient has said occurred during this conversation, which means it's now a he said, she said scenario. The doctor claims one thing, my client says another thing. Who's the jury to believe? Who is more credible? If the jury were able to hear this particular recording, then yes, they would recognize that my client was correct. This is exactly what happened during the conversation. But because you have chosen to conceal that information from the defense, now there is no possible way the judge is going to allow us to use that information. In fact, it may be so prejudicial that the jury has now heard and learned of this. There is the potential that the judge would find this to be so prejudicial and create bias in favor of us at this point. It is possible that the judge could declare a mistrial. Unlikely, but the judge could declare a mistrial. And that means that all the days and weeks of preparation and trial will be out the window, and then we'll have to try this case all over again. In addition to that, if we knowingly and willingly conceal that information and then try and bring it up at the time of trial, the defense lawyer could easily turn around and ask the judge to fine us monetarily or sanction us for withholding critical information that we had many years earlier and failed to disclose. And that would be a huge, huge problem. So, what is the answer to that problem? As soon as we learn that you have this information, the best strategy, the best tactic to use is to exchange that and turn it over to the defense. This way the defense lawyer can get it, he can talk about it with his client and try and do things to diffuse the information contained on it. And by the way, even if we turn this information over in a timely fashion, at the time of trial, I guarantee you that the defense attorney will still try and object and try and prevent us from getting this audio recording in front of the jury. So why do I share this useful information with you? I share it with you just to give you a sense of what can happen when an injured patient goes and tries to record a conversation with their doctor surreptitiously, hidden, and now tries to ambush the doctor with it at the time of trial. You know, I realize you have questions or concerns about your own matter. Well, if your matter did happen in New York and you're thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.